Yeah, Your Honor.
Yes.
I beg to mention item number 5, Your Honor. The leading counsel is out of station.
Who is the leading counsel?
C. Modi. I'm from the respondent side.
You are for a respondent.
Yes. Respondent number 2.
Who is for the appellant? Have you taken
I'm for
consent?
the state, Lordship. I'm for the state.
Have you taken consent from the
Yes.
appellant side?
Yes, please the petition.
I'm put a appellant.
The learned counsel MS so and so. The appearing for the respondent submits that the learned conducting counsel, Mr. C. Modi, is not available today, and on that ground, an adjournment has been prayed for. I have also heard Mr. Al Parme, the learned counsel for the appellant. Heard MS Al Hage, the learned additional PP for the state of Assam. The hearing is adjourned accordingly, at least after 2 weeks.
God bless you.
Lordship, I beg to mention item number 6, Lordship.
6.
Yes, Lordship. I am for the appellant and I have taken consent from the other side, Lordship. Can it be taken day after tomorrow, Lordship?
Tomorrow,
Day after tomorrow.
day after tomorrow. Heard Mr. S. Tapin, the learned government advocate in relation to this. Mr. Tapin has prayed for an adjournment and also submits that he has already informed the other side. Accordingly, the hearing is adjourned today, at least day after tomorrow.
Lordship, most of it.
My lord, this item number 1, as per your lordship direction, my lord, we have communicated to the department asking for some, my lord, information, exactly how long they will take time to frame the rules, my lord. So that instruction is awaited, my lord.
It's for, it's been third consecutive time.
My lord,
It's been third consecutive.
my lord, I can understand that, my lord. Since the issue is very sensitive, it's indigenous, my lord.
Are
How
you
many
implementing it? Has
Well,
it been implemented?
act is already there, my lord.
No, has it been implemented?
Yes, my lord, it's implemented,
Without rules, how can you implement?
my lord. But act itself is suffice because suppose if anybody lodges complaints to the deputy commissioner, the course of action is there. And there is no such abandonment made in the petition that they lodge a complaint, there is no action from district.
No, that is
nothing
the
like
problem. The act provides that, but you
Well,
have to frame the rule.
Yes, my
Otherwise, it cannot be implemented.
correct. Absolutely, my lord. So for that, my lord, they are taking longer time, my lord.
No, only whether your rule has been framed or not, it's a matter of a second only. Whether rule has been framed or not.
My lord, not yet, my lord. What they say is, my lord, is active under constitution, my lord. So your lordship may kindly give us some more time so that I can take a proper instruction from the department. What exactly, my lord, they are doing that.
Let it be then last time, last chance, my lord. Otherwise, my lord, my humble prayer would be for
According to you, whether this law has been implemented or
no, my lord.
it has not been implemented.
No, my lord. Broadly, this act has two objectives, my lord. Now, for any in any case, my lord, the simple punishment cannot be objective of any act, my lord. Now, main objective of this case, my lord, has yet to be implemented, my lord. Main objective, my lord.
London AG? What is this? 1978 Act. You are yet to frame the rule. And you are implementing the law without framing rules. Freedom of Religion Act.
Your lordship will give me some time, my lord. I'll get back. I'll personally take it up.
Sometimes it's been 3 consecutive times.
I'll personally take it up. Your lordship will fix it on, I'm coming back on. Lordship, may I have it on 24? I'll come back on 23rd. I'll personally.
One last chance.
And Mr. L. Permet, learned counsel for the petitioner. Mr. Arich Naba, learned additional advocate general, is granted 2 weeks time, 2 weeks further time to file affidavit in opposition. No, additional affidavit, bringing on record. No, affidavit in opposition, additional affidavit as directed by this court on 10/01/2024. Mr. We have requested the learned advocate general of the state to assist the court in this matter, along with Mr. Arich Naba, learned additional lady.
Your Lordship, may fix it on 24th.
It's a particular date, my lord.
List it on 24th,
24.
24/09/2024.
Obviously.
My lords, for Arunachal University, my Arunachal University and Himalayan University, this rejoinder has been filed to the respondent on the last day.
You are for
Arunachal University,
petitioner.
yes, my lord, for
Then-
petitioner.
Have you filed the rejoinder?
Yes, my lords,
When?
last date, on 1st August, we have filed the rejoinder and also supplied to the respondents accordingly.
No, no, John.
But office note says that rejoinder if it not yet filed. What happened?
We are yet to receive any copy.
Yes, office note says so. Maybe in some other matter. I mean, which case, which writ petition you have filed?
Arunachal University of Study versus State of Arunachal Pradesh.
Arunachal University.
Yes, my lord.
That is item 2.
And the rejoinder, to the best of my information, rejoinder has been, I'll file during the course of
What
the day.
information? Your lawyer, your counsel for the petitioner?
Arunachal University of Study,
Yes.
my lord. And to the best of my information, the rejoinder has been filed, but
Are you for petitioner or
Yes,
are you
my
for
lord.
respondent?
for petitioner.
What's the question of your information? You have to be
uh,
sure whether you have filed a rejoinder. Office note says something else.
I'll file a rejoinder during the course of the day. I was informed that rejoinder has been filed on last day, but by now I have just come to know that rejoinder has not been filed.
Do you have a briefing counsel?
Yes, my lord, I have briefing counsel and
Who is briefing?
the local council. What is the name? The DK Dao is my senior counsel and
Senior counsel?
yes,
briefed
my
you?
lords, and there is local counsel who briefed me about
Senior counsel briefs you.
No, my lords, DK Das is senior counsel and their junior counsel has informed me that the rejoinder has been filed on last day. And just now I came to know that rejoinder has not been filed. I'll file that during course of the day.
Had Mr. So-and-so, learned counsel for the petition. Mr. I Chaudhary, learned additional, learned advocate general, this state. And Mr. T. Thakur, T. Jamo, learned standing counsel, education department. Oh,
Regulatory commission.
respondent number 3,
3, my
standing counsel for Arunachal Pradesh Public Education, Private Educational Institution Regulatory Commission. Cover respondent number 3.
For education department and government.
This is
On rejoinder has been filed. Last evening.
office note dated 07/09/2024 reflects that the petitioner is yet to file the rejoinder affidavit. Mr. So-and-so, learned counsel, is granted for the 3 weeks time to file rejoinder.
My lords.
List after 3 weeks. 3 weeks.
Matter may be fixed in 17 lords. I'm told that if you could not for disposal. This matter is pending about 2 years.
You want it on 17?
Inside the.
Who is for the respondent number 2? Notice served on
Respondent number.
notice not yet served. You serve the notice first. Hard Mr. Kitapa, appearing for the appellant, RMS L. Hage, the learned additional public prosecutor for the state of Arunachal Pradesh. The appellant is directed to take steps for service of notice upon the respondent number 2 by registered post TTD.
Police.
Not query, through the concerned police station. The appellant shall take steps accordingly. List after 4 weeks.
Yes, sole respondent, because 2 times I've taken the service, but on both the occasions, it comes that address moved. So I have to verify the address.
The learned counsel, Mr. S. Saxena, appearing for the
Petitioner, petitioner.
okay, petitioner, submits that on 2 occasions, notice upon the sole respondent could not be served because of wrong address. So therefore, Mr. Saxena prays for some time to verify the proper address of the sole opposite party respondent. And the prayer, Mr. Saxena is allowed. List again after 4 weeks.
My lord, I would like to mention item 21, my lord.
21.
21, yes, my lord. Your lordship had taken this up on Friday, my lord. And Mr. D. Boje had appeared. And your lordship had granted some time to file wakalatnama. But today my sister, who is associated with D. Boje, she has informed that Mr. Boje is out of station and the client is as well out of station. My lord. So my lord, others may pray, my lord, lordship, that we may be allowed to take steps, my lord, on the respondent.
Steps upon whom?
On the respondent. At the stage of motion, my lord, because since Mr. Boje had appeared, Mr. D. Boje, he had not filed any wakalatnama. So your lordship had granted some time.
Okay.
But
You are appearing for whom? Huh?
she's appearing on behalf of Mr. D. Boje.
Oh, sir. Mr. Bose did not file any wakalatnama.
No, ma'am.
Yes, sir. He is out of stations.
Will you file wakalatnama?
I've been informed that yes,
Sir,
I've been informed that Mr. Boje is out of station as well as the respondent, my lord, in the CRP, my lord. The respondent is also out of station. So let in May pray, my lord, notice we will take steps upon.
No, if the Mr. Bose files wakalatnama,
My lord,
if Mr. Bose files
no,
wakalatnama,
sir. Due to the transportation problem, the respondent is unable to reach here. So my humble submission is to give some time for the wakalat and file the wakalatnama.
let him file wakalatnama.
my lord, then
Heard Mr. D. Soki appearing for the petitioner, heard MS
Miss Yadam Mosi.
appearing on behalf of Mr. D. Bose. The learned counsel for the respondent submits. Thus, because of some personal matters, Mr. Bose is yet to file the wakalatnama. And therefore, the learned counsel prays for some time so that Mr. Bose can file the wakalatnama. The prayer is allowed. List after 2 weeks.
My lord. The interim order may be continued.
The interim order pastillation will continue until then.
Obvious.
Yes.
May I please, my lord?
Yeah.
My lord, I beg to mention item number 15.
Uh,
I'm appearing for the sole respondent,
Item number 15.
15 million. We'll file our reply, so the matter may be posted after 2 weeks.
You are for the
Sole respondent.
sole respondent. The learned counsel, Mr. So-and-so, appearing for the sole respondent submits that he needs some time to file a reply in respect of the affidavit in, you are for a respondent.
Yes, for the respondent. Affidavit in opposition.
He needs some time to file the affidavit in opposition. Who is for the petitioner?
Petitioner counsel.
I have also heard Mr.
Dilona.
Appearing for the petitioner. The prayer of the learned counsel for respondent is allowed, least after 3 weeks.
Obliged.
I beg to mention, your lordship, item number 30 and 31 of today's supplementary hearing, your lordship, criminal appeal.
Item number?
30 and 31 is a connected matter, your lordship.
Also.
Your lordship, the conducting additional BP, my learned colleague sister is sick, and for that, your lordship, she is unable to pursue this matter. So this matter may be listed after puja break, your lordship.
Zini.
Genie, yes, your lordship.
Okay. Mr. T.A.P., the learned additional public prosecutor, has submitted that the learned conducting additional public prosecutor MS T. Gini is not available today, and on that ground an adjournment has been prayed for. Who is appellant? Hard MS N. Anju.
Lodge.
Appearing for the appellant. The learned amicus curiae, appearing for the appellant. The prayer, Mr. Ete, is allowed. List up to the ensuing puja vacation. Along with item number 31.
Deeply obliged, your lordship.
May I, Your Lordship? I beg
Yes.
to mention item number 32, Your Honor.
32.
Yes, on behalf of Uttam Dika, Your Lordship.
Hmm.
He is not able to appear today.
You are appearing on behalf of CMOD.
Udika, he is the leading counsel here, Udika.
Also, Uttam Deka
Yes. Your Honor, may we fix this item on 17 September? Your Honor.
on 17.
Yes.
The learned counsel MS So-and-so appearing on behalf of Mr. U. Deka prays for an adjournment. After hearing the learned counsel, the prayer for adjournment is allowed. Least on 17 September
God bless you.
for hearing.
Lordship,
Clear.
I am mentioning item number 27 on behalf of D. Pang, Lordship. Learned Counsel, Mr. D. Pang could not able to attend the court today because of his physical illness. So, Lordship,
You are
this-
for the appeal. Least after 2 weeks.
deeply obliged, Lordship.
Your Honor, I'd like to mention item number 3.
Item number?
Item number 3 on behalf of the Mehdi.
Item number 3.
Yes, Your Honor. Counsel is out of station, Your Honor, so this matter may be listed on Wednesday.
You are appearing for Mr. B. Deka.
Yes, Your Honor. Oh, yes, Your Honor.
The learned counsel, Mr.
H. Tai.
Appearing on behalf of Mr. B. Deka, the learned counsel for the Petition have praised for an adjournment. When do you want it?
On Wednesday, Your Honor.
Wednesday?
Yes, Your Honor.
Next Wednesday, with the date.
Obliged.
Your Lordship, I am to mention item number 16, Your Honor,
Item number 16.
for adjournment.
16. Criminal petition.
Yes, Lordship.
You are appearing for Tito Poo.
Yes, yes, Lord.
What is your name?
T. Iru.
The Learned Counsel, Mr. T. Iru. Appearing on behalf of the Learned Counsel, Mr. Tito Poo. Praise for an adjournment. The prayer for adjournment is allowed. Least up to 3 weeks. Yes,
May I please, Your Lordship?
yes.
Lordship, I'm challenging the order passed by the learned section judge.
Where is the order?
Lordship. Lordship will find it page number 63, Lordship. Annex C.
Yes.
Yes, Lordship. Lordship, the fact involved in this matter, Lordship, is that, Lordship, the petitioner and the respondent, Lordship, they are staying as a husband and wife, Lordship. In the year 2002, the family member of the both the parties has recognized them as a husband and wife, Lordship. And after their wedlock, Lordship, three sons has been born, Lordship. One is 19 years and another one is 16 years and the last one is 9 years, Lordship. What happened, Lordship? Since the petitioner and the respondent, Lordship, they have belong from the Nishi tribe, Lordship. Nishi tribe of the state, Lordship. And in the Nishi tribe, Lordship, as per the customary laws, Lordship, polygamy is prevalent in the community, Lordship. So what happened, Lordship? In the year 2022, Lordship, when the petitioner, Lordship, he fall in love with another woman, Lordship. And after approval of the consent, consent has been approved from the first wife, Lordship, that is the defendant, Lordship. She consented that you can go for a second marriage also, Lordship. And both the family members were present in the meeting, Lordship. And thereafter, accordingly, the petitioner has married the second wife, Lordship. And thereafter, what happened, Lordship? After a few years, Lordship, the defendant has having an extramarital affairs with another man, Lordship. Since the Lordship, the second marriage is prevalent in the Nishi community, Lordship, she is also entitled to be as a wife of the petitioner, Lordship. Now, what happened, Lordship? Thereafter, Lordship, in the month of January, Lordship, 2024, Lordship, she left the home without informing the petitioner, Lordship, in order to stay with another man with whom she is having an extramarital affairs, Lordship. And thereafter, interestingly, Lordship, when the petitioner, he tried to contact her, Lordship, she did not respond to the phone, Lordship. And she filed a divorce petition, Lordship, before the Session Court, Bomdila, Lordship, District and Session Court, Bomdila, Lordship. Interestingly, Lordship, the divorce petition has been filed by invoking Section 10, subclause 1 and subclause 10 of the Divorce Act, Lordship. Whereas, Lordship, the law is very specifically clear in this Divorce Act, Lordship. Divorce Act will be only applicable to the person who professes the Christian religion, Lordship, not the other religion, Lordship. Now, having be there as it may, Lordship, the petitioner filed an application by invoking Order 7, Rule 11 of the CPC, Lordship, praying for rejection of the plain, Lordship. Since the petitioner and the defendant, they are from the Doni Polo, that is the local religion, Lordship. So instead of considering the fact that she is not Christian, petitioner, Lordship.
Oh no, what ground?
On the ground that, Lordship, Lordship will find from the paragraph 2, Lordship. Paragraph 2, Lordship. The region order has been given here, Lordship. May I read, Lordship? I have heard Mr. Defendant regarding the missed case 4 of 24, which is registered out of the petition under Order 7, Rule 11 of the CPC. It is submitted by learned counsel for the defendant that plain filed by the plaintiff is required to be rejected as provided under Order 7, Rule 11, subclause D of the Civil Procedure Code. As present suit appears from the statement of the plaintiff to be barred by law. It is submitted that present divorce proceeding is not maintainable under the Indian Divorce Act, as plain does not reveal that the marriage was solemnized under the Christian marriage. It is further submitted that Section 20 of the CPC provide that suit is to be instituted in a court within which the jurisdiction defendant actually and voluntarily choose or carries on a business or personally works for gain at the commencement of the suit, where the cause of action, holding or in a part arises. It is submitted that all the parties present case resided in Itanagar within the jurisdiction of the Papumpari district. No cause of action within the jurisdiction of this court. As such, this court has no jurisdiction for trial of the present divorce proceeding. It is submitted that the present divorce proceeding may be rejected and plain filed by the plaintiff to be rejected as provided under Order 7, Rule 11, subclause D of the CPC. I have heard Mr. appearing for the plaintiff who submitted that the application filed by the defendant under Order 7, Rule 11D of the CPC is liable to be rejected as same is not tenable in present case. Now, Lordship, the observation will come at paragraph 4, Lordship. I have carefully perused the respective pleadings of the parties and found that learned counsel for the defendant has raised objection that plaintiff has not mentioned that the marriage between the plaintiff and the defendant was solemnized as per the Christian religion and the Divorce Act is applicable to them. I have seen preamble of the Divorce Act and other relevant provision of the Act. It is observed that Divorce Act 1869 is formulated to amend the law relating to a divorce of person professing Christian religion and to confer upon certain court jurisdiction in matrimonial matters. Section 2 of the Act provides that extend to whole of India except the state of Jammu and Kashmir. It is further provided nothing herein after contained shall authorize any court to grant any relief under this Act except where the petitioner or respondent profess Christian religion. Said provision clearly shows that Act is applicable to a person who professes Christian religion. Nowhere in the Act it is provided that Act will be applicable only when the marriage is solemnized as per rites and rituals of Christian religion. The present case, plaintiff in paragraph 2 clearly mentioned that the petitioner professes Christian religion. As such, there cannot be any prima facie ground to reject the plain on the ground that Divorce Act is not applicable to them. It is further observed that post title of the plain defendants Sri so and so present resident of village UAPA Sanction within district of East Coming, Arunachal Pradesh, which is well within the jurisdiction of this school. The plea of the defendant resided Itanagar Papumpari district served in the office of the Chief Engineer Western RWD Itanagar is not to be considered at this stage as provide to decide the jurisdiction of this court. Plaintiff has pleaded that defendant is resided within the district of this court and defendant has taken the plea that he carries on a business or work for gain at Itanagar out of jurisdiction of this court. Such rival submission to be decided by the court examiner of the witness, same cannot be decided before the trial is commenced and at the preliminary stage As the plain prima facie revealed that this court has territorial jurisdiction, as such prayer for rejection of the plain is hereby rejected, Lordship. Now, Lordship, when I file Order 7 Rule 11 application, Lordship, I have specifically stated in my application that since we are at the time of our marriage, Lordship, since I have already go for a second marriage also, Lordship, if we were solemnized as per the Christian rituals, Lordship, the second marriage is prohibited, Lordship.
Okay, I will issue notice.
Lordship. In the meantime, Lordship, I am praying for a staying of this judgment also, Lordship. Otherwise, Lordship, this will set a wrong precedent, Lordship. Either the defendant has to file an application under Section 9, read with Order 32 of CPC, Lordship.
I have Mr. T. Gaurav waiting for the petitioner. Issue notice to the sole respondent.
Lordship.
The petitioner shall take steps for service of notice upon the sole respondent by registered postage ID. Least after 4 weeks till returnable date. the further proceeding of divorce case number 03 of 2024. Pending in the court of, where is it pending?
Court of Learned Session Court, West Siang,
Not
West-
district,
West coming.
district judge,
District Judge West coming.
West
Lordship, right.
Sessions Division, Bomdila,
Lordship,
Odisha Pradesh, Suleiman State.
Lordship. Deeply obliged.
Yes.
May please, Your Lordship. All of this revision is directed against a judgment and order passed by the Learned District Judge on an application under Order 7, Rule 11. Very interestingly, my lord, the issue is that the petitioner filed a suit for divorce before the Learned District Judge. The respondent filed an application under Order 7 D. Though it's D is not mentioned, but from the contents it can be understood. It is, their contention was that the suit is barred by law on the ground that as there is a customary court, therefore the district judge would have no jurisdiction to decide a divorce suit. We objected to that application, saying that there is no express or implied bar as it is required under Section 9 of the CPC, Your Lordship knows. And relying on the judgment, the principle laid down by the Honorable Apex Court in Dhulabhai and our approval bench judgment of Daulatram Lakhani, the Learned District Judge accepted that contention that it has jurisdiction. However, in an application under Order 7, Rule 11, the district judge the suit for filing it before the customary court, which is, in my respectful submission, is exceeding of jurisdiction. Because the Order 7, Rule 11, Your Lordship knows, there is the only scope is either to reject the plaint or to proceed with the suit. There cannot be an order under Order 7, Rule 10. It's a return of plaint. However, this order under cannot be also constituted Order 7, Rule 10 because the Learned District Judge invoked the jurisdiction under 151, the inherent power. If Your Lordship finds, and very interestingly, the petitioner, there was an order of the village authority against the petitioner directing her to cohabit, irrespective that she was subjected to cruelty and there is a divorce proceeding pending. Against that order, appeal is preferred. A statutory appeal is preferred before the Learned Civil Judge Senior Division. Now, by this, the Learned District Judge also interferes with that appeal, which is pending before some other court. So therefore, this application, this revision is under 227. Necessarily, my lord, under Order 7, Rule 11, the order, if any pass, is appealable. But here, the plaint is not rejected. And an order has been passed whereby the plaint has been returned to the plaintiff for filing it before the customary court. And that too, invoking 151. Therefore, I have filed this under 7, my lord. If Your Lordship finds the impugned judgment at page 126, starts from 126. One paragraph which I would like to show Your Lordship.
Paragraph number?
Paragraph number 21 at 134.
Yes.
First, my lord, will see para 20, my lord. And this order is passed in the interest of justice to both the parties, applying the provisions of 151, as both the parties are indigenous with the direction that the plaintiff shall approach before the customary court as to whether the applicant defendant has a right to obtain decree of divorce in a fresh proceeding of Kapang. Now, my lord, to find para 21. Further, as the applicant defendant has obtained a decision to enforce conjugal or cohabitation with respondent plaintiff, and the same is pending in the appeal before the Learned Civil Justice Division. In order to avoid multiplicity of the courts, the pending appeal before the Court of Learned Civil Justice Senior Division may be withdrawn by the applicant defendant. My lord will read this as the plaintiff opposite party, my lord, because the appeal was filed by me. Or treated as infructuous on presentation of a divorce suit by the plaintiff respondent before the customary court, with a direction that the applicant defendant may also press his conjugal rights before the customary court, as it noted upon the Kapang decision that the decision was no more or less than an ex parte decision, as the respondent plaintiff has walked out from the proceeding of the Kapang decision on the day of the Kapang. Here, my lord, the Learned District Judge also comes to comment on the appeal, which is pending before some other court, my lord. Now, Your Lordship, my lord will stay the operation of this judgment.
Heard Mr. B. Kaushik, the Learned Counsel appearing for the petitioner. Issue notice to the sole respondent. The petitioner shall take steps for service of notice about the sole respondent by registered post AD. Least up to 4 weeks. it is further directed that until further order, the
Judgment in order dated
judgment and order dated 20/08/2024
but
passed by the learned district judge Pasighat in
IA number 6 of 2020
IA number 06 of 2024
arising out of divorce suit
arising
number.
out of divorce suit number 04 of 2024 shall remain stayed.
My lord, record may be called for.
Hmm?
The records may be called for.
Record is not required, it is a matter of law only.
Yes. Grateful, my lord.
Resolved. Only non-combustible offense is 324 IPC. Kindly come to page number 19. Earlier, the FIR was registered under section 341, 325, 307, 376.
Is this a joint petition?
Yes, joint petition. Husband and wife.
Husband and wife. Where is the FIR?
FIR, Lordship, page number 14. If you can find. the
14?
FIR. 14. 14.
14.
Yes. Kindly see the sections, it is under, so there are 5 sections are inserted. But later on, after investigation, at page number 19, there is reduced to only 3 sections, and one of them is only 324 is, that is
Under what section the charge sheet was filed?
341, page number 19,
Page number 19.
19. 341, 324, 506.
506.
Since 341 and 3506 are compoundable, 324 is non-compatible.
Saying, what is it?
All this, almost except one, my lord, all the sections are compoundable. And more
Okay,
of this husband and wife.
It's quashed.
And
None appears for the appellant to call. List after 3 weeks.
Lord, it is an application of 482.
Lordship, my senior is out of station. My senior is out of station. Council Mr. K. Lawrence.
Who is your senior?
Lordship,
Who is your senior?
conducting council Mr. K. Lawrence is out of station. Conducting council Mr. K. Lawrence is out of station.
K. Nolan.
K. Lawrence, Lordship.
My lord, for last several months, now I'm coming from Guwahati, my lord. They took time. And on the other hand, my lord, I have been pressurized by my client, my lord. So far as their prayer for adjournment is concerned, I have no objection. But Lordship may kindly stay the, my lord, proceeding. I am trying, my lord, for several months to get an order. Whether, my lord, they.
Okay, I will stay the proceeding.
My lord.
Heard Mr. A.K. Purakasto appearing for the petitioner. Heard Mr.
Zita, Lordship.
Zita
For the respondent.
appearing on behalf of the respondent number 2. Mr. Taye submits. Zita.
Yes.
Mr. Taye submits that the learned conducting counsel, Mr. Who is your senior?
K. Lawrence, Lordship.
K. Nolan.
Yes.
Is out of station and on that ground an adjournment has been prayed for. I have also heard MS L. Hage, the learned additional public prosecutor for the state of Arunachal Pradesh. There. After hearing both sides, the prayer for adjournment is allowed. List after 4 weeks till returnable date. The further proceeding of GR case number 87 of 2022.
Arising out of Kamba.
Arising out of Kamba PS case number 07 of 2022. Pending in the court of
Order, my lord. Order,
Chief Judicial Magistrate, Civil Judge Senior Division,
yes.
West Siang District, Allo,
Hello,
Arunachal Pradesh, shall remain state.
my lord, oblast.
Yes.
There's an bail application which I have filed. For
Under what section the trial is going on?
no charge set yet framed till date.
Your Lordship, here the two offenses from UAPA Act, Your Lordship. The as per the material so far is the record, Your Lordship. The present applicant is a active member of NSCN-U. This self-styled, Your Lordship, organization, Your Lordship.
How many witnesses are already examined? How many witnesses?
Your Lordship, a trial not commenced, Your Lordship. We
Trial,
have sought for Your Lordship sanction under UAPA Act, Your Lordship. Sanction, Your Lordship, to prosecute under Unlawful Activity Prevention Act, Your Lordship. I have marked Your Lordship in the.
Take that plea before the trial judge at the time of framing charges.
Just I had played, you may read at page 22, Your Honor, because since page 22 of my petition.
Page 22.
This is the order by which it was sent back to the JMFC. The fourth para. Although the IO filed charge sheet against all the accused person under section 384, 507 to section 10, 13 UAP Act. In absence of prosecution sanction, find no reasons to take cognizance of the offense under section 10 and 13 of UAP Act. Hence, the offense under is triable by the judicial magistrate first class. Let the case record be transmitted to Court of Learned JMFC, Khonsa for trial. That means I am languishing in jail because they had not filed sanction.
The sanction is awaited, Your Lordship. The sanction has been sought by the investigation agency as on that, Your Lordship.
That cannot be a ground for keeping me in the custody.
But the offense involved is punishment is up to life, Your Lordship.
That is true, Your Honor. But they had filed a charge sheet in a piecemeal manner, just to avoid me from getting bail, because that is the time bound. If they don't file the charge sheet within time, then I get a default bail. Just to curtail me from that right, they filed a charge sheet without sanction.
You have to wait for some time.
Otherwise, material is there, Your Lordship. I have marked the material which is there in the LCR, Your Lordship. I have done the plague mark there, Your Lordship.
Heard, Mr.
DK David.
DK Dev. APA for the petitioner. Heard, Mr. T. Attended on additional public prosecutor for the state of Rhode Island. Para. The petitioner was charge-sheeted in a case under sections 10 and 13 of the Unlawful Activities Prevention Act. Stop. He was also accused of doing some offenses under the provisions of Indian Penal Code. The learned counsel for the petitioner submits that the charge sheet was filed without the mandatory prosecution sanction. Stop. Para. Mr. Ate submits that the police is now taking steps to get the prosecution sanction. Para. I have considered the submissions made by the learned counsels on both sides. Para. This is that if the police authorities are trying to procure the prosecution sanction, they should be given some time to that effect. The police authorities are directed to procure the prosecution sanction within next 2 months. Is it okay?
Yes, Your Lordship.
After getting the prosecution sanction, receipt of the prosecution sanction, the petitioner is at liberty to approach this court seeking bail. With the aforesaid direction, the present bail application stands closed and disposed of.
Yes, sir. Deeply obliged, Your Lordship.
My lord, these
Yes.
matters
been pending since 2019. This may be taken up on 19 for
Final disposal.
Final disposal.
Yes, ma'am. Eight, 9, 10, 11 is mine, my lord. 12, 13 is Mr. Kato. We've discussed with Mr. Kato.
Eight is yours.
8, 9, 10, 11 is mine, 4.
8, 9, 10, 11 is yours.
And then 12, 13, Mr. Kato, I have discussed with him also.
Okay. Heard the learned counsel, Mr. So and so. Appearing for the appellant, the petitioner.
Petitioner.
Heard Mr. H.R. Nawam, the learned additional government advocate.
Additionally, AG, my lord.
Additional government advocate, additional advocate general. On the basis of the submissions made by the learned counsels of both sides, the matters are adjourned today, list on 18.
19.
19. 19.
19
September.
September.
Endeavor shall be made to dispose of them on the day.
Very good.
Obliged.
Obliged.
Yes.
Your Honor, this respected court has directed to take step on last occasion, and such we had taken the step.
You have taken steps.
Yes, sir.
But somebody appeared upon the respondent.
I'm on behalf of appellant.
You are for the appellant.
Yes.
Earlier, Mr. K. Posi appeared for the respondent. Hard MS. What is your name?
D. Boni.
Appearing for the appellant. None appears for the respondent on call. This is limitation. Limitation allowed or not? Since none appears for the respondent on call, the matter stands adjourned today. List after 2 weeks. After 2 weeks.
Your Honor,
Yes.
I on behalf of the leading counsel, the Morik Bagra, from the petitioner side, and in this case, we already filed the step taken in the Daily newspaper and already submitted the
Objection.
and already submitted the matter in this honorable court, but yet no response from the other party. So, Lordship, matter may be fixed for next hearing for ex parte.
Okay. None appears for the petitioner on call. Heard, Mr.
Tirar.
Appearing on behalf of the sole respondent. Since none appears for the petitioner on call, the case is adjourned today. When do you want it?
After 1 week.
List after 1 week.
Deeply.
Yes.
My lord, this matter is been not since 1 year. They have not filed any affidavit in opposition.
Affidavit in opposition.
No, because the rule may be issued, my lord. They will file accordingly. Oh,
My lord,
his counsel is here.
my lord, although recently I received pairwise comment, but it's not been supported by any relevant records and other additional documents. I sought for other information, my lord. This is incomplete. The instruction has been received, my lord. So I need some more time, my lord, to receive the complete information, the instruction. my lord.
One chance I will give.
My lord, this is, I think, history. Last 1 year, not a single piece of paper.
That is.
This is a record.
Heard Mr. T. Son.
1 week, my lord.
Appearing for a petitioner. I forgot your name.
My lord,
T.
T.
Son.
Tagum, my name's standing council education,
Standing council for the
health department. my
health
lord.
department. Mr. Son has pointed out that for a long period of 1 year, the respondent has not yet filed the affidavit in opposition. On the other hand, the learned counsel for health department has submitted that he has not yet received all the instructions necessary for filing the affidavit in opposition. Therefore, Mr. So-and-so prayed for some more time so that he can file the affidavit in opposition.
My lord, in the meanwhile, rule may be issued, my lord.
Okay. After hearing both sides, the prayer for the learned counsel for the health department is allowed. 2 weeks' time is allowed for filing the affidavit in opposition.
My lord, in the meanwhile, rule may be issued, my lord.
My lord,
They may file affidavit, no problem.
Okay, after 2 weeks,
it will list, yes, sir.
List after 2 weeks.
My lord, deeply obliged.
Notice not yet served upon the respondent number 2.
Your Honor, still no any report is served. I have taken the steps. Steps has been taken, but it's awaited.
You want to wait again?
Your Honor, I'm going to take trace steps.
Trace steps.
Yes, ma'am.
Heard, Mr.
Actually, Your Honor, it is inform me there's notice has been received by the respondent number 2. So, my lord.
But the report is not here.
Yes, yes. Okay, Your Honor.
Heard, Mr.
BR does, my lord.
Appearing for the appellant. Heard, MS.
Dirilung for the respondent number 1, and today, Lords, I'm going to submit wakalat nama.
Okay, all right. You want to find the wakalat number?
Yes.
Hard MS so-and-so, appearing for the respondent insurance company. Today she has filed the wakalat number. I have gone through the office notes. It appears that service of notice upon the respondent number 2 is not yet complete. Therefore, the appellant is directed to take fresh steps for service of notice upon the respondent number 2 by registered posted AD. List after 4 weeks.
Yes. There will be mentioned that the respondent number 1 has received their notice February 28, 2024. Still, they have not submitted WS. The last chance may be given to them.
What they will file? They are not required to file anything.
They have received notice on 28 February 2024. This 6 months.
Respondent 2 has to be take the step first. Respondent number has not taken the step.
Okay, you take steps for respondent
I
number
will
2.
take steps.
Let
but-
the both parties appear after that.
Yes.
And my lords, in this case, I'm praying for Passover. My senior is on the way. He'll be here within 5 to 10 minutes.
Who is your senior?
Mrigen Singh is my senior, my lords. He's the outstation counsel. He's on the way. Maybe taken after regular list.
Okay, let him come.
Yes. Highly
None appears for the applicant on call. Hard MS L Hage, we learned the additional public prosecutor for the state of Arunachal Pradesh. Since none appears for the applicant on call, the matter stands adjourned today. least up to 2 weeks.
Right.
Lordship, it's a joint petition by the husband and wife, but during the pendency, your lordship, it has been the culminated into FR, your lordship, final report.
Oh, final report submitted.
Yes, your lordship.
So there is no question of quashing.
Yes, your lordship.
My lord, I have a very limited prayer, my lord. My lord, if the FIR may be quashed, my lord. If the FIR may be quashed, my lord.
No, entire if the final report has been filed, there cannot be any quashing. What I will quash.
Yes, your lordship. And if they have settled the matter, there is no any question, your lordship protests the same.
Yes. Heard Mr.
80 more.
Appearing for the petitioner. Heard Mr. Petitioners. Heard Mr. T.A.T. the learned additional public prosecutor for the state of Arunachal Pradesh. This is an application under section 528 of BNSS 2023, praying for quashing the FIR number 35 of 2024, registered by Women Police Station, Itanagar, under section 85 of BNS Act 2023. Para. This is a dispute between husband and wife. Para. Mr. Ate has submitted that police has filed a final report.
Number, your lordship, 83 of 24.
Final report being number
83 of 24, dated 16/8/24.
Para. Since finally filed, there is no necessity of exercising the power under section 528 of BNSS 2023. With the aforesaid view of this court, the present petition stands closed and disposed of.
Deeply obliged, your lordship.
This is yours.
In item number 29, madam. 29. Oh, sorry.
28.
Sorry.
None appears for the appellant. RMS L. Hage, the learned additional public prosecutor for the state of Arunachal Pradesh. Since none appears for the appellant on call, the case is adjourned to least up to 2 weeks.
Right.
My lord, I'm appearing on behalf of A. Sahid, my lord, for the petitioner, my lord.
You are appearing for Ace ahead.
Yes, ma'am. My lord, if the matter may be taken after 1 week, my lord.
1 week later.
Yes, my lord.
Heard Mr. Appearing for the petitioner. The learned counsel has submitted that the conducting counsel, Mr. A. Sahid, is not available today. And on that ground, an adjournment has been prayed for. After considering the submission of the learned counsel, the prayer for adjournment is allowed, least next week.
That's
yes.
My senior is still, he's on the way. I pray it may be taken on 12:30 if lordship would allow us to argue. He's on the way right now, Malaj.
This is the last item.
That's
My lord, item number 22, my lord, I'm appearing for, it's my IA, my lord, that I have filed.
You have item number 22.
Yes, my lord, I have filed my IA, my lord. My lord,
You
what has
filed-
happened?
You filed the IA.
Yes, my lord, I have filed the IA. I am the original complainant, my lord. My lord, what has happened is that the honorable court on the first day, when the matter was moved, did not pass any interim order. Thereafter, my lord, on 19/6/2024, the court passed an order that my lord, page 19. In the meantime, page 19 at bottom, my lord.
But the counsel for the other side is absent today.
My lord, may I just submit here, my lord? My lords, in the principal sits have passed judgment that an interim or no course of action and interim order
in criminal petition case can only be passed after perusing the case diary and after looking through entire records. My lord, in this matter, my lord, no case diary had been looked. My lord, no case diary had not been looked, and the order at page 90 also reflects the same. And it was only till the next returnable date. And thereafter, my lord may see on page 21 and page 22, my lord. Page 22.
Yes.
My lord, the interim, the matter was listed on 28/8/2024. And the respondent here is not me, my lord. It was the public prosecutor who had prayed for time. But they did not, the Honorable Court did not extend the interim order. So, my lord, my entire submission is this. My lord, the judgment of the Supreme Court, my lord, is very much clear. And my lord's own judgment in the principal seats have been clear that in a criminal petition case, there's no coercive action cannot be entertained without perusing the case diary. My lord, at order at 19/6/2024, there was no.
Now you want the case diary to be called.
My lord, the case diary had been called many times. However, the case diary had not been submitted. So, my lord, that is why in 19/6/2024 there was no reflection of case diary. Only on the context of that the senior counsel is appearing. My lord, there was not even a pursuit of the case diary and the order was passed. My lord, this is absolutely against the law that is holding the field right now. That you cannot stop a criminal proceeding. And my lord, if they are so much apprehensive that they will be arrested, they can go for anticipatory bail. Because my lord,
their other side is not available today.
My lord, they are available. My lord,
Next Monday. Next Monday.
Next Monday.
Next Monday.
My lord, the senior counsels who has to argue this matter is from the MP, from MP Jabalpur, my lords. So it could be possible. It may be taken tomorrow, my lords. I on the board.
Next Monday. Ask him to do it by video conferencing.
Pardon, my lords?
By video conferencing, he's from MP.
Yes, my lords. He's from
He can do it by video conferencing.
My lord,
what is your name?
Jaideep Kaurav, my lords.
Huh?
Jaideep Kaurav. Yes.
The learned counsel, Mr. Yes.
Ma'am, I apologize, my lord. May I just submit one thing, my lord? My lord, because there is no coercive action has been passed. My lord, I have an apprehension that the investigation will be stopped. So, my lord, at least today, my lord may say that the no coercive action may be there, but that investigation may continue, my lord. Because, my lord, this is a serious.
Yes.
The investigation will continue. The
Okay,
investigation
all right.
cannot be halted.
Mr. Jaideep Gaurav.
May I submit, my lords?
Yes.
It could be taken on 23rd, my lords, if it's possible.
23rd, you take it on Monday next. If you do it by video
Next
conference,
Monday is not possible because my lords, senior has to. There is a family engagement in his family, my lords. That is why I on 23rd. It's Monday.
The investigation will continue.
My lords, what I am submitting is, my lords, there is an interim relief in favor of the petitioner, my lords. So, just passing this order behind the back of the petitioner counsel, my lords, it would be not be appropriate for the court also to pass this.
That is the discretion of the court.
Absolutely, my lords. I go down to your observation, my lords.
Because in the
Just next interim relief may be continued till the next date. And
the interim relief.
my lords, what has happened in this case, my lords, on the for a moment, my lords, the order sheet which has been filed by the respondent counsel, for a moment they may be perused by the my lords, on 19/6/2024. The court
interim relief has already been granted to you.
Yes, my lords.
No coercive actions will be taken against you.
Yes, my lords.
But what about the investigation? Investigation will continue. No coercive actions will be taken against you.
Investigation part may be continued, Lordship. Otherwise, Lordship, we could not call for the updated city also because the investigation was stopped, Lordship. So it may be continued.
Investigation will continue, but no coercive actions will be taken against you. Mr. Jaideep Gaurav, appearing on behalf of the petitioner. Mr. Gaurav submits that the learned conducting counsel, Mr.
Mrigen Singh, senior counsel Mrigen Singh.
Senior counsel, Mr.
MRIGENDRA.
Mrigen
Singh, SINGH. Yes.
He is not available today, and on that ground, an adjournment has been prayed for. I have also heard Mr.
SP Sharma. SP Sharma.
AP?
Sharma.
SP Sharma.
SP Sharma.
SP Sharma.
Sharma.
Appearing on behalf of the respondent number 2. RMS L. Hage, the learned additional public prosecutor for the state of Arunachal Pradesh. On the submissions made by Mr. Gaurav, the case is adjourned today. Para. List on when do you want it? When do you want it?
My lords, on 23, my lords, I pray
On
for-
23 September.
Yes, ma'am.
On 23 September. The earlier order that no course of action shall be taken against the petitioner shall continue till next date of listing. However, the police investigation shall continue as per law.
Much obliged.
List again on 23rd.
Much obliged, my lord. Much obliged.
Lordship, in the item number 24, Lordship, we may be allowed to call for the updated case study.
Item number 24?
23, Lordship.
23.
Lordship.
Which one? This one.
It's connected, it's a criminal petition, Lordship, main petition.
Huh?
Criminal main petition, 23, Lordship.
23 is the criminal petition. This is the I.
Lordship, 23, Lordship, for 23, I'm playing.
It will be listed along with item number 23.
On the meantime, Lordship, we may be allowed to call for the updated case study.
Updated case diary. You wait for some time. Let the police investigate some more things after that. On the next date, I will call the case diary. Okay.